Namaste ji, namaste. So in part 1 of our series of judgments, we had discussed till Mukesh Kumar. This is part 2. If you haven't watched part 1, then please do so. Then come to this lecture. The link to this PDF is in the description box down below. You can download it from there. So another judgment that you'll need to remember, it's Common Cause versus Union of India. The topic was that does Article 21 include a right to die with dignity? What is Article 21? That is right to life. So does that include the right to die with dignity? Well, the Constitution bench decided that right to life with dignity under Article 21 includes a right to die with dignity. I have linked the judgment in the PDF down below. Public Interest Foundation versus Union of India. This is that whether you'll be disqualified from your legislative post just on the mere framing of criminal charges against you. So 5-judge bench of the Supreme Court held that a person cannot be disqualified from membership in a legislative body on the mere framing of criminal charges against them. This is an important judgment. Then we go to Yeshwan Sinha versus CBI, in which the Supreme Court considered that whether some documents that were leaked and that are protected under the Official Secrets Act, if they are leaked and if they are produced to the court as evidence, are they admissible in evidence? So yes, the court held that the documents classified under the Official Secrets Act, if leaked, can be admissible in the court. The judgment is linked. Now this is for the sexual harassment case that happened against the former CJI, I believe Ranjan Gogoi. So this is in that is reference, matter of great public importance touching upon the independence of judiciary. So this isn't exactly some versus wala format of case law. This you'll have to remember, this is a very crucial thing in which the in-house committee, they dismissed any and all allegations of sexual harassment. This again was related to the Rafael case. Then we come to Navdat Singh Johar. This is a pretty popular judgment. I'm sure that you already know of it. This is where the Supreme Court decided on the constitutionality of Section 377 of the IPC, wherein a 5-judge bench unanimously struck down Section 377 IPC. That does not mean that Section 377 from the IPC is gone. It only struck down Section 377 IPC to the extent wherein it was affecting or criminalizing same-sex relationship between two consenting adults. So the provisions relating to bestiality and other non-natural, you can say, or unnatural forms of sexual intercourse, they still remain valid. The judgment is linked in the document. Then we go to Joseph Shine. Again, both judgments came out pretty much right next to another. So Joseph Shine versus Union of India is decriminalization of adultery. This is Section 497 of the IPC. The court decriminalized adultery. It struck down 497 of IPC. Then this is Shafin Jahan versus Ashokan KM. This is also popularly known as the Hadiya marriage case, in which the father alleged that his daughter was forcefully converted, and well, she was married into another religion, but then she contended something else. She said, well, it's my choice. So this is known as the Hadiya marriage case. So if in any of your law entrances they ask you which is the Hadiya marriage case, this is Shafin Jahan versus Ashokan KM. The pronunciation could be Hadiya as well. I really don't know. It says Hadiya, so I'm pronouncing it based on that. Now Justice K.S. Puttaswamy versus Union of India, in which constitutionality of the Aadhaar Act was decided on, and it was held that right to privacy is a fundamental right, and usually all these rights are declared under Article 21. All right. Then we go to Indian Young Lawyers Association versus State of Kerala. In part 1, we've already seen the review petition ka naam, that is Kantaru Rajivaru versus Indian Young Lawyers Association. Herein the custom of the Sabrimala temple was held that it was unconstitutional by a 4:1 judgment. The one judge that dissented, that's Justice Indu Malhotra, she has just retired, and I believe Justice Banerjee is now the only sole remaining woman judge in the Supreme Court. This is Government of NCT of Delhi versus Union of India. थोड़ी सी पुरानी सी judgment है, but it is relevant especially this year. Why? Because the government, or rather the Union of India, has amended the Government of NCT of Delhi Act. Alright, so the 69th amendment becomes important for this year. The article number 239AA, that is the special provisions for Delhi, they become important. Herein, the court judged that the chief minister and not the lieutenant governor is the executive head of the National Capital Territory government. तो इसी judgment को almost आपने परे कर दिया है in 2021 by enacting, or rather amending, the core act that relates to Delhi. Then Shaira Bano versus Union of India, that is triple talaq is unconstitutional or not. a constitution bench declared that the practice of instantaneous triple talaq is unconstitutional. Mind you, two judges dissented. So Chief Justice at that time, J.S. Khair and Abdul Nazir, they dissented. So three agreed, well, yeah, triple talaq is unconstitutional, and two, they dissented against it. Then DU's favorite keeps on asking this judgment, that's Abhiram Singh versus CD Commission. That's the electoral appeals case. I have written the decision here. I need not read the exact thing from the board. You can read it from the document. Bijo Emmanuel versus State of Kerala, very crucial case law. Herein, it was quite old now. In July 1985, three children were expelled from their school for not singing the national anthem. So the Supreme Court of India found that the expulsion of school children for not singing the national anthem, well, it was a violation of their right to freedom of speech and expression. Then another case law relating to national anthem, and don't get confused when they ask you, be very careful in trying to determine कि आपको कौन सी judgment पूछी जा रही है, because the law entrances, they especially try to confuse you, especially when there are two topics on the same, or are the two judgments on the same topic. So this is Shyam Narayan Choksey versus Union of India. तो इसमें ये भैया कभी खुशी कभी गम देखने गए थे, and well, he stood up for national anthem as everyone should, but then nobody else did. In fact, they started making fun of him. So in this case, the Supreme Court held that please, well, you'll have to show respect, and then they modified this order later on, in which they held that it is not mandatory for cinema halls to play the national anthem. So cinema hall national anthem is Shyam Narayan Choksey, but पीछे वाला, that is ये आपके जो school kids वाला, so that is Emmanuel versus State of Kerala. Be careful between these two judgments. All right. This is the Jallikattu case. This is Animal Welfare Board of India versus A. Nagaraj. This is also known as the Jallikattu case, in which the SC held forcing and pulling the bull by a nose rope into the arrow. Basically, it said, you know, you can't, this is too much cruelty towards the animal. So they banned the sport. Right. And that's about it. Rest of the classic judgments such as Golaknath, Minerva Mills, Keshwanand Bharati, etc., all the constitutional law judgments I've already discussed in previous videos. I have also linked to these videos in the document that is linked in the description. I believe that's a sufficient number of very high probability judgment when you combine lecture 1, lecture 2 of for this year. So I believe that should sort out most of the judgments that they can ask you in your law entrances. All right, wishing you all the very best. Take care.